SJC-11872, Burbank Apartments Tenants Association and others, v. William K. Kargman and others.
Good morning. Is it Ms. Jochnick?
Good morning, Your Honor. That's correct.
You may proceed.
Good morning, Your Honors, and may it please the Court. My name is Ann Jochnick from Greater Boston Legal Services, representing the appellants. This case is about a landlord that seeks to exempt itself from the fair housing statutes and to turn down a rent subsidy that would pay market rents.
Well,
Exempt itself from the fair housing statutes?
That's correct, Your Honor.
Exempt? You mean just by transferring from a project-based subsidy to another form of subsidies?
That's what the owner says, Your Honor, that they're just somehow the fair housing laws just don't apply to that kind of situation, even though by refusing the rent subsidy in question, which would pay market rents, it will disproportionately exclude people of color, disabled people, elders, and others protected under the fair housing laws, as well as create a barrier to integration.
well, now, all this has happened by virtue of a decision not to re-up, right? That's all it is.
That's correct, Your Honor.
And is it possible even now to go back on that and to re-up at this point?
There may be ways to do that.
Maybe, you're not sure?
There are different ways.
I thought that the project-based financing, once discontinued, was over.
There may be ways. No, well, the financing is there's a bunch of different programs, but only one is relevant here. The mortgage, which is not relevant, is over.
Right.
The project-based Section 8 subsidies are renewable.
They were renewable, but I mean, I thought that they were not being done anymore in new projects.
Not for new developments, but for owners that have already had like this owner that have already
Or
had.
declined it as of 2011, right?
That's correct. But
And
there's-
there was no injunction requiring the owner to do it at that point. So my question is, 5 years later, 4 years later, is this really something that could even be done?
We believe that it is, Your Honor, and what we're asking for is that in the relief that we're asking for is merely that the owners continue to operate the development as if the project-based subsidy were in place.
And if the project-based subsidy could not be put in place, what would happen?
The
Saying that the owner should still operate it as if it were in
That's the
place?
relief, but what we're asking the owner, there's nothing that the owner has pointed to that says that HUD cannot provide a project-based subsidy at this juncture. And what we're asking is that the owner,
Do they
the
not
owner
do
could
it any-
ask HUD for the subsidy. Sorry.
No, go ahead, I'm sorry.
It could look for different kinds of subsidies that would continue to maintain the affordability of the development. It could project-base the enhanced vouchers. There's a whole lot of different ways that the owner could meet the goals that we've requested in the relief. But at this point, there's nothing that the owner's pointed to that says that they can't get a new project-based subsidy, and that is not the relief that we've requested. And it may be that the owner is able to get a new project-based subsidy. It may be that they're able to get a different kind of subsidy that would maintain the long-term affordability of the development.
So this is a private property,
Correct, Your Honor.
and it is in full compliance with all of the statutes and agreements with respect to the subsidies it has been getting. It is transitioning out of one form of subsidies into another. And you're saying that, once you're in the program, period, you're in the program, no matter what the law says, no matter what your financial agreements say, no matter what your agreements with HUD say, you're in forever.
What we're saying is that although the subsidy program rules don't require the owner to continue the project-based subsidy in question here, the fair housing laws do apply.
But there's a whole mechanism for transitioning, and they're in compliance with offering all the things that one has to offer in transition. That's a whole federal program set up and designed to be that way?
The word transition is nowhere in the legislative history of any of the programs. There was no intent by Congress to create a transition. There's no transition for the first person on the waiting list or for any of the other prospective tenants.
We're talking about the current tenants, though.
So, yeah, with respect to the current tenants, there's a different set of claims than with respect to prospective tenants. So with respect to current tenants, they're receiving, if they were eligible, a different kind of subsidy that we have alleged is not as good as the project-based subsidy for a variety of reasons. It can put-
You're saying the enhanced voucher is not as good?
For current tenants. For prospective tenants, it's irrelevant
I
because they don't
understand
get
that, but
them.
why isn't it as good for current tenants?
Because of differences in the program rules, with enhanced vouchers, tenants could be at greater risk to having to pay greater amounts of rent. As happened to one of the named plaintiffs, Byron Alford, who has had to pay a greater rent. They're not as stable a form of subsidy, they're more at risk of being cut. There's a variety of program differences that make the enhanced vouchers for current tenants more detrimental, and that's what the allegations have with respect to current tenants are, in addition to their losing their ability to live in an integrated community, which the Supreme Court has recognized as a protected interest.
So from your perspective, if I understand correctly, you say there's no difference between where the owner, as that term has been defined in this litigation, is than in the cases that you cite and rely on where it was complete cutoff from any Section 8 or anything like that. Is that, they're exactly the same? Is that?
With respect to prospective tenants, they're exactly the same. In one scenario, the prospective tenants, including the first person on the waiting list and named plaintiff Satisha Cleckley, would have had the opportunity to move in, paying market rents, and under the second scenario, which the landlord has chosen, they cannot, and the landlord knew that they would no longer be able to move into the development.
So, under what are there any circumstances that you can conceive of where this landlord could cease participate? Is there any circumstance in which this landlord could do what it is now seeking to do?
There's a variety of circumstances. If the project-based subsidies weren't available at market rents, but paid less than a market rent, if there was an alternative subsidy that would pay market rents that incoming tenants could use to move in, there may be no disparate impact. If the landlord decided it no longer wanted to use the property as rental property, the landlord might not be able to get out of the, turn down the project-based subsidies.
You mean he convert it to condos?
Sorry?
He could convert it to condos. Is that what you're saying, or no?
There may be no disparate impact claim if if the owner decided to do something else with a rental property, because in that case, although there might be a disparate impact, the owner would likely or arguably have a business necessity to do it, because they couldn't turn it into condos with the project-based subsidies in place. If they could, maybe there wouldn't be a business necessity.
How has this been resolved in other places? I mean, I can imagine that when the 40 years is up, that there will be a lot of owners who will want to get out of the program. Are you aware of any cases that have come out the way that you're asking us to come out otherwise in the country?
Well, interestingly, since Congress has allowed, in 1999, started to allow owners to get actual market rents for these subsidies, only a very small portion of owners have actually sought to terminate the subsidies, and that's discussed more in the amicus brief from the Sargent Shriver Center. But in terms of other cases, there is the Gray Oak case where, the Charleston Housing Authority case where the owner there, just like here, sought to prepay its mortgage, tried to terminate the project-based subsidies, and
had no
ultimately sought to
alternatives.
demolish the building.
Right? Didn't have any alternative. I mean, that's where the transition comes in, right?
Well, there was no alternative subsidy in that case, Your Honor, but there's no alternative subsidy for prospective tenants in this case. And in the Charleston Housing Authority case, the court found that there was a disparate impact on both current and prospective tenants. And in addition to the Gray Oak case, there's all the Brown case from this court, the Delito case, where
That was not brought under the federal, that was brought under the state, the Brown case, right?
correct, that was Brown. But in Brown, the court looked at a very similar issue, and it said that, and it concerned a landlord that
Mr. Brown would not process Section 8 applications.
right.
Which is significantly different than this situation, where there's no allegation that this landlord is unwilling to process.
The allegation in this case is that the landlord is willing to process a project-based subsidy, which
Not a
is
project-based one, but whatever tenants come that they have, they're willing to take them.
only if they pay the market rents, which there's no dispute that any other kind of subsidy would pay. So the landlord recognizes that, and the named plaintiff, Satisha Cleckley, is a case in point. She didn't have a voucher, but if she did, at the time of, and this is reflected in some of the expert affidavits in our case, but at the time that she applied, the owner was planning to charge for a one-bed, she has a young child, the owner was planning to charge for a one-bedroom unit $1,600 to $1,800 a month. And she didn't have a subsidy, so on her $500 a month income, she couldn't afford to move in. But let's say she had had a Section 8 voucher or certificate like the ones at issue in the Brown case, the maximum payment standard under the program for the Section 8 vouchers at the time for a one-bedroom unit was only $1,263, as compared to the $1,600 to $1,800.
Brown case, it was not a question of whether or not the vouchers would cover or not cover the rent that Mr. Brown was charging, is that he simply didn't want to process Section 8
He didn't
vouchers.
want,
So
correct,
he wouldn't do applications for people who had them. That's a significantly different situation, don't you think?
it's no different in this case. In Brown, Mr. Brown was seeking to refuse all subsidies at its units, even where the subsidy would pay market rents. It's identical to this case where the landlord is seeking to refuse the only subsidy that would pay project-based Section 8 that would pay market rents.
But it's not refusing, the landlord is not refusing to accept the enhanced
Correct.
subsidies that are provided.
And but the prospective tenants can't use enhanced vouchers. So for prospective tenants, just as in Brown, this landlord is refusing the only subsidy that they can use to move in, because it's the only subsidy that would pay market rents.
Well, isn't that somewhat curious too, because you're saying that it would pay market rent, but doesn't HUD set the rent at the beginning of the contract, and that doesn't necessarily mean it's going to stay market rent during the entire time of the contract?
HUD sets the rent at the beginning of the contract. The contract can be for 5 years,
So
generally.
market rates in Boston are really quite
Sorry?
on the rise. Market rate in Boston for rents are rising all the time. So
And
there
in-
could be periods of time when they're in fact not getting market rent.
In the intervening years, the HUD is allowed certain increases, and at the 5-year mark, they're allowed to go up to market rates again, or down, depending on whether because it could be that the increases in the years 2 through 4 are actually over market rents. So it could work both ways. But at this point, in this case, what the tenants have alleged, the landlord is turning down a market rate subsidy, and there's been no contradiction of that.
Can you address your sister's preemption claim that essentially if you do everything that Congress said you should do, that there's essentially a safe harbor from a Fair Housing Act claim?
Yes, Your Honor. In the first place, there's no explicit preemption contained in the Section 8 statutes. And in the second place, this court in the Brown case very clearly, or directly on point, addressed the preemption argument in two ways. It looked to it looked to the overall statute, and it said the statute just lays out the requirements, the funding, but doesn't preclude application of the state fair housing laws. And then it also looked to the language of the Section 8 statute, the purpose of which is in the very beginning of the statute, and it said, which says, Congress says the purpose of the Section 8 statute is to create affordable housing and to create economically mixed developments. And so it found that the purposes of the Section 8 program and the fair housing laws were the same, and there was no conflict preemption there. And there's nothing that the landlord has pointed to in this case, or the owner, that is any different from, that changes that language which is in the Section 8 statute. And in fact, to create this kind of exemption would be contrary to the very purpose of the Section 8 program.
Could I just ask you, the Supreme Court's case, Inclusive Communities, which came down in 2014, I think. 2015. Now, it certainly recognizes that you can have the kind of discriminatory effect you're alleging here.
That's correct, Your Honor.
But it also limits, in a way that wasn't present in these other cases, what you have to do to establish a prima facie case. And some of the language in there, I think, is interesting, and I'm not completely understanding how it is that your complaint gets around them. Because it says, disparate impact liability may not be imposed solely on a showing of statistical disparity. And you can't establish a prima facie case if a statistical discrepancy is caused by factors other than the defendant's policy. That you have to meet a robust causality requirement by pointing to a defendant's policy or policies causing the statistical disparity. And finally, that it requires a practice or policy, and that a one-time decision may not be a policy at all. And all I'm seeing here is a one-time decision. So how is this a policy at all?
Well, starting with the first, with the last question, this, almost anything could be considered a policy or a decision. So what the courts have said is the way there are some one-time decisions where an owner denies one person a housing, you can't make out a claim of disparate impact because the comparison group is too small for any kind of meaningful comparison. But when a decision or an action or a policy affects a large number of people such that you can make out a meaningful comparison, then that decision is actionable under the disparate impact theory and under the fair housing laws.
There are cases that talk about this?
That's correct, Your Honor. I believe it's called Council 31, and it's in our brief.
Okay.
And in this case, it's clear that the owner had made a choice that had a disproportionate disparate impact on a large number of individuals that are protected under the Fair Housing Act in comparison to the tenants that will be able to move into the development. So there's no question. With respect to the robust causality, in the other concerns of the ICP, in the Inclusive Communities case, in ICP, what the U.S. Supreme Court's recognized is that the disparate impact analysis always has contained certain safeguards. And those safeguards are contained in the three-step burden shifting process. Steps 2 and 3 are not relevant at this stage in the pleadings. What's relevant is...
Saying you don't have to allege the robust causality?
Well, that's in step 1, and we have alleged it. What we've alleged is that this owner's actions in refusing to renew the project-based subsidies has disproportionately denied housing to tenants of color, others protected under the Fair Housing Act, and it has created a barrier to integration. It squarely meets if the owner had accepted the project-based subsidies, the tenants would have been able to move in, and without the project-based subsidies, they could not. Now, I don't know if you're alluding to, well, they're low income and that's caused by something else. That could be caused by something else, but even the the court decisions in what the U.S. Supreme Court called the heartland of disparate impact. For example, the zoning cases, or even the Griggs case, the employment case that preceded disparate impact in the Fair Housing Act. In the zoning cases, the defendants didn't cause the plaintiffs in those cases or the low-income people to need the affordable housing that the zoning was going to prohibit. And likewise in Griggs, which is the employment case, the employer's provision requiring high school diplomas and requiring the certain tests to be passed didn't. The employers didn't cause the applicants in question not to have high school diplomas and not to have not to be able to pass the tests.
Right.
So,
I think you're over your time, so thank you.
thank you, Your Honors.
Good morning. May it please the court, I'm Janet Lundberg. I represent the appellees in this case, the Burbank Apartments owners and managers. This case is not a situation in which an owner is refusing to accept any Section 8 subsidy or is attempting to withdraw completely from the Section 8 program. This is not a case involving any allegation at this point in the case of intentional discrimination or alleging any animus toward any protected group at all. What this case involves is a situation where Congress created an affordable housing program that had a 20 to 40-year obligation for developers who were induced to enter the program, but most importantly, a program that had a specific beginning and had a specific end.
Are you talking about the 221D3, or are you talking about Section 8?
I'm talking about both of them because all of the statutes, and there's 5 that we go through at some length here, talk about the fact that the subsidy program, the Section 8 subsidy program that went hand in hand with the 221D3 program, mortgage program.
Except that it wasn't in existence when this owner joined the...
But a similar program was. And then in 1982, I believe, Section 8 was passed. And when the owner here gave up its right to end its mortgage, to prepay its mortgage after 20 years, under the ALIPA statute, the owner here entered into an agreement under Section 8 in accordance with ALIPA and then LIPFRA and then all of those statutes that we cite in our brief. And the contract said the Section 8 agreement is only meant to go for so long, is only required to stay in place for so long as the mortgage is in place.
Yeah, I don't think there's any question about the fact that there's this complex scheme that makes it, that permits these things to be voluntarily assumed or not. But the question is, even if you have a complex, you don't really get into Fair Housing Act problems unless you also are doing something according to law, right? You can, well, okay, let me put that a different way.
You never reach it?
It's not that you can't reach legal action if it has a disparate impact.
That's true.
So you can be in compliance with zoning. For example, there's a zoning ordinance that has a disparate impact, and you can be in compliance with it. You can have met it completely, but that still doesn't shield you from a Fair Housing Act problem.
That is true, but what we are saying is that in this case, Congress did far more than just say, you may leave the program after a certain period of time. Congress actually did exactly the opposite. In all of these statutes, Congress actually legislated and said, when your mortgage is paid off, you may not leave the project-based subsidy program unless you do what we say, which is to convert to the enhanced voucher program.
But knowing about the Fair Housing Act and its breadth and its purposes, and the fact that there have been disparate impact claims brought before and since, during this entire period of time that the subsidy program has been in existence, the Congress never specifically referenced the Fair Housing Act and said anything like notwithstanding, or there will be no liability for a landlord who does this under the Fair Housing Act. There's nothing specific that exempts or immunizes.
that what you're saying is true, but what we're saying is that you must look at the overall statutory and contractual framework that was set up in these multiple statutes, in which every single statute recognizes that owners will opt out, have the ability to opt out, are granted the right to opt out after 20 or 40 years,
Go ahead, finish.
I was just going to say, and make specific provision for that eventuality. We're saying in that situation, Congress would not, it would be error to assume that Congress would have created a program that had a termination scenario which in and of itself would result in discrimination liability for no other reason than that you complied with the program.
I take it that the whole purpose of these programs is to actually create incentives for the development of affordable housing.
Correct.
And that was Congress's purpose, is the purpose behind the scheme. So suggesting that, well, that may have been the purpose, but there's a catch that we're not going to tell you about until the end, that is likely not to incentivize too many people to engage in these programs.
Well, and that is precisely the overall policy problem with the appellant's position. I believe that, first of all, it requires, the appellant's position would require any owner to eschew the discretion, the right given to it by Congress to opt out of the program in numerous numbers of situations. The only way that you could leave the program without being subject to a discrimination claim would be if your development already exists in a low-income area and in an area where protected classes predominate in the demographics of the area. In that situation, appellants say there would be no impact because your market rents would still allow the same people to live there as lived there while the project-based subsidy was in place. Everyone else, like this particular development in the Fenway, which is not in that situation, they can never leave the program.
But if one assumed that the FHA applied, what do you say about whether or not the tests articulated in the new Supreme Court case?
Yes. I think that our first argument is, of course, as we said, we think congressional intent indicates that disparate impact analysis should not apply at all, and that would be giving the congressional intent in those affordable housing statutes its due. However, even if the disparate impact analysis is applied under inclusive communities here, it's our contention that the appellants cannot meet the pleading standards articulated in inclusive communities for the first time, even if they were given another chance to do so. Since I know inclusive communities came down after the trial court's decision here.
Although he knew it was pending,
He knew it was pending, but of course we didn't have the benefit of the guidance.
or what they were going to say.
Right. So first of all, I would say that the inclusive communities decision makes very clear that a plaintiff must plead a prima facie case in the complaint. And the appellants and their supporting amici, they are wrong to claim that the case does not permit dismissal and instead requires in every instance where they've pleaded simply statistical disparity that they get to move on to the full-blown three-step litigation process. I think the case is very clear, and in some of the language that you were quoting, Justice Lenk, that as a pleading matter, what's required is pleading statistical disparity and causality, that any effect is caused by some policy of the defendant and not by some other cause. Both things have to be fully alleged in the complaint, and if they're not dismissal.
Aren't they saying that it is caused by the defendant?
They are, but if moving to that, if those two things were alleged in the complaint, they weren't alleged sufficiently. Number one, on statistical disparity, they have three groups of tenants or potential tenants that they address in their complaint. The existing tenants all received enhanced vouchers instead of project-based subsidy. those enhanced vouchers allow them to stay in their apartments at Burbank forever, or for as long as their lifestyle choices lead them to stay there. Now, the fact that the appellants think that some of the terms of those vouchers are not as good as what the tenants had under project-based subsidy, I would say that is not a problem caused by Burbank. That is a problem caused, if there is one, by Congress and HUD, who put the program in place. And furthermore, of course, there's an extreme benefit to the tenants from the enhanced vouchers, which is they're mobile. They can go anywhere they want to. They don't have to just use them at Burbank. The second group is potential tenants who hold housing choice vouchers. As stated in our brief, however, the HUD regulations would prohibit anyone holding a housing choice voucher from utilizing a project-based subsidy unit. And so those housing choice voucher prospective tenants would have no claim to force Burbank to keep project-based subsidy in place, because they wouldn't be able to utilize it if it were in place. So that leaves one unspecified group of low-income people who might have been on the waiting list or might not have been, who have no subsidy whatsoever and who might someday want to live at Burbank. And
So I'm sorry, could we come back to your second one? You said you have
Sure.
potential tenants with housing choice vouchers. Are those the Section 8s that don't pay market rent?
that,
Do
that-
not pay market rent?
those are the ones that do not pay market
And you're
rent.
saying that those folks would not have been eligible for the project-based voucher?
That's correct,
Why,
under HUD
why is that?
Pardon me?
Why is that?
HUD regulation prohibits the holders of housing choice vouchers from using units that have project-based subsidy.
I see.
And that's always been the case?
I couldn't tell you for how long that has
No,
been.
but I mean, it isn't within the last, I don't know.
No. No. We cited it in our brief, I think for the first time. It did not come up earlier in the case. But in fact, it does support this trial court's decision with regard to that group of prospective tenants. So I would argue there's no impact on those tenants. And thirdly, getting to this group of tenants with no subsidy whatsoever,
Who could have used the project-based?
they could have, had they been able to get into and utilize the units. But what I want to say about that is that to allege an impact for that group requires that they have to be able to show that there are units that have become available because enhanced voucher holders have left the project. Because in fact, the project received more than 67 enhanced vouchers because of the owner's prepayment activities. The project actually got vastly more enhanced vouchers than had previously, than the 67 units that previously had been subsidized. And so in order to allege an adequate case, they would have to show that enough enhanced voucher people had left such that were there project-based subsidy there now, some of these people without subsidy could get into the building.
So you can't allege simply that that's an inevitability that there will be.
I say, and the trial
Yeah.
judge said, that's entirely too speculative. And in fact, it's not in the record, but I can tell you that if we're forced to go back and litigate this issue, there are still 68 enhanced vouchers residents in the building. One more than the 67 units that were subsidized by the project-based subsidy. So I would argue that even under the Inclusive Communities case, the appellants cannot allege impact, have not and cannot allege impact. Moving to the causality aspect, excuse me.
Let me just ask you a background question. How long does the landlord have to make available units for purposes of unit-based vouchers?
For the enhanced vouchers, forever, basically as long as the program is funded and the tenant stays in the unit. And that was made a requirement, I think, at the MARA stage, in that statute where they actually specifically Congress legislated a right of the tenants to stay. And so some of these cases cited in our brief at footnotes 30 and 31, that all involved cases challenging owners who wouldn't accept enhanced vouchers. Some of them wanted to convert to condos. And the courts said no Under the new statute that says they have a right to stay no matter what you want to do with your property, those enhanced voucher holders must be allowed to stay there. And so at the point, though, when the enhanced voucher tenant leaves, then the unit becomes free of subsidy unless there is another voucher holder who's able to come in. And the fact that the government will not pay actual market rent or anything close to actual market rent in this neighborhood is, again, a problem created by the government. People holding mobile vouchers are forced to live in lower income areas because of the government's payment standard policies, not because of anything that Burbank did.
Now, enhanced vouchers can also be mobile, right?
Correct.
So there could be, theoretically at least, somebody who is on the waiting list who has an enhanced voucher
No,
from
well,
some
from
other,
another place?
From another place.
Yes, but at that point, once they leave the place where they got the enhanced voucher, it becomes a regular voucher, I believe, and it's subject to the same payment standards as regular mobile vouchers. It loses that
Market value.
market value, that's right. Briefly on causality, we would say that this is precisely the type of policy that the Supreme Court in Inclusive Communities said should not be the basis for causality, because it's an attempt to second-guess a choice between two reasoned government policies. It is not a direct negative prohibition against protected classes living in some area of the city, that is the heartland type of discrimination claim that the appellants are referring to.
What are the
not this
government
choice between.
policies? What are the government policies that you say are that they were trying to second guess the choice between government policies?
That the government decided to make available tenant-based, to allow you to continue in project-based subsidy or to convert to tenant-based subsidy in the form of enhanced vouchers when you end the program and the mortgage program. And the government recognized that there would be a right to choose between those two programs. So the government set up a voucher-based system, and it set up a project-based system, and it said you choose. And so those are and the government made the choice as to the fact that both of those should be available. And just one last point, I know my time is up, on causality. Another basis for causality is if the effect results from economic imbalances, if the unavailability of affordable housing results from economic imbalances that are not the fault of the defendants. That's what the Supreme Court said. And here, I think, actually, the amicus briefs filed in support of the appellants assists our position here, which is that we did not cause the economic imbalances at Burbank that are causing the effect that appellants are complaining about. Appellants say no longer having project-based subsidy here will mean that fewer protected classes can live at Burbank, and it's tied to their claim that this will decrease integration in the Fenway neighborhood and increase segregation in the other neighborhoods where people are able to use their non-market rate tenant-based vouchers. I think the amicus briefs at some length demonstrate that the segregation in the city of Boston that appellants are trying to address through this case was caused by historical injustices of many decades and by the failed government policies such as the mobile voucher program that will not allow protected classes to live in economically advantaged areas. And so it would be our contention that there's no causality based on the defendant's actions here, but that any causality or of impact was a result of other factors not caused by Burbank.
All right, thank you.
If there are any other questions?
I'm
Thank
afraid your
you.
time is up, but thank you.